All right, let's get started. Thank you all so much for tuning in. So this is the title of the webinar that we've all signed up for. We'll be doing future planning for Kinship Caregivers with Jacqueline Adorno, Mobilization for Justice Lead Attorney. This is a little bit about PSS and who we are. Founded in 1962, we provide a variety of different services for kinship caregivers. Oh, great. We've already got a question. Wonderful. Give me 2 seconds, man. Hold on. PSS, founded in 1962, is an innovative multi-service agency. And PSS Life University, which is what you're all participating in, provides these educational services. We also have PSS Circle of Care, which we provide free personalized support for folks who are caring for someone who's frail, chronically ill, or has memory loss, and families where a grandparent or family member other than a parent is raising a child. And our grandparent family apartment buildings is the first U.S. residence purposely built for grandparents raising those grandchildren. This is a little bit more information about our programs like coming of age, the 10 different senior centers we have, and the fact that we're always looking for folks who want to volunteer and be interested. Please type any questions or comments into our chat box. We'll respond to as many as we can. Like we have a question we've already got here. And with that said, again, thank you for participating, and there's the ability to learn more. So I'm going to kick this off to Jacqueline over here, and thank you all so much for coming again.
Hi, everyone. Huge thank you for taking the time out to be here for this webinar. I know we all have a lot going on. I hope that at the end of this hour, I would have given you some information to at least give you a little bit of peace and some resources to help you plan for the future. So let me just pull up my slideshow here. Okay, here we go. So my name is Jacqueline Adorno. I am the supervising attorney of the Kinship Caregiver Law Project at Mobilization for Justice. Today's webinar is going to be about future planning, and the material that I'm going to discuss today is specifically for kinship caregivers. I want to leave everyone with some resources if they do have children in their care. And, you know, with everything that's going on right now, I know folks are really worried. What if something happens to me? How can I plan so that way the child that's in my care, there's a plan in place. If I'm unable to care for this child, who in my family or who in my community could step in? So during this webinar, I'm going to discuss parental designation, standby guardianship, healthcare proxy, and living wills. I did see that there was a question down, and I do encourage everyone to, you know, as this webinar progresses, to ask questions at any time in the chat box below. I will be answering the question. I think it's a very important question. I did anticipate it, and I believe it will be covered in this webinar. So before I go into the 4 subjects for today's webinar, I did want to provide some information on the Kinship Caregiver Law Project. And I apologize, I think there's a plane or something going on overhead. So the Kinship Caregiver Law Project is actually the only program in New York City that has a program dedicated to providing legal services for kinship caregivers. The clients that we serve are non-parents. We define kin quite broadly. Majority of our clients are grandparents, but it could be, you know, aunts, uncles, sisters, siblings, someone who has assumed a familial role, often referred to as fictive kin, all who are caring for children that are not biologically their sons or daughters. And we assist them with a variety of legal issues ranging from adoptions, custody, guardianship, foster care advocacy, grandparent visitation, and a special form of immigration relief for undocumented youth referred to as Special Immigrant Juvenile Status proceedings. We service the 5 boroughs, and the way that we define that is if the actual case is within the 5 boroughs of New York City, we can assist that caregiver. So there are a couple of scenarios where, let's say grandparent is in New Jersey, but the case is in the Bronx. That would be a case that we could assist that person with. We have attorneys who speak Spanish on staff, but we also do have access to live translation services that would allow us to serve pretty much any language that the client speaks. So for the first subject for today's webinar is parental designation. This is a great resource, regardless of the current health crisis, that I think all parents and anyone caring for a child should know about and have access to. This is a form that can be signed by both either the parents or a legal guardian. So for kinship caregivers, if you do have a custody or guardianship order, you can sign this form. And what this form allows is for you to designate basic medical and educational decision making to a third party. So a perfect example of this might be if you have a scheduled hospitalization, for example. You know you're going to be in a hospital, or you might have a long rehab period where you won't be able to really attend educational, go to school whenever school reopens, or take the child to the doctor. This is a form where you can designate a third person to make those decisions on behalf of the child. This is a form of informal custody, so there is no court requirement. All you need is for the person who has either the parent or the legal guardian to fill out the form, and if it's notarized, it can go for up to 1 year from the date of notarization. If it's not notarized, which is really difficult right now, but I will talk a little more about notarization in the time of COVID and a little bit later. If it isn't notarized, this document is valid for up to 1 month. Now, this form allows this person to make educational and medical decisions for the child. You can actually specify what type of decision making you want this person to make on behalf of the child. Time pre-COVID, let's say grandma has limited mobility and can't really get to the child's school with as much frequency as she would like. What she can do is fill out this form and allow, let's say, one of her sons or daughters to be able to go to the school to make some educational decisions regarding that child. Same thing with doctor's appointments. If there's limited mobility, you could then designate someone to make those decisions on behalf of the child. This, because it's an out-of-court remedy, it can be revoked at any time. Like I said, you can include specific instructions for the person that you're designating to have this decision-making power over the child. In households where there's more than one child, you will need a separate form for each child. One parent is enough, so you don't need the signature of both parents, but that one parent must have decision-making authority over the child. So let's say, for example, in a scenario where mom and dad, mom has sole custody of the child, she would have to fill out the parental designation. The dad who doesn't have sole custody wouldn't be able to do that. But in a scenario where there is no existing custody order, either parent can sign that form. And what we've experienced is that oftentimes a lot of kinship caregiving arrangements start off without a court order, and this is often the first step in that arrangement. But this is definitely a resource that kinship caregivers, if you do have custody or guardianship, you can use this to your advantage. And I think, given the current crisis, this is definitely a good tool to have, a good resource in the event that, you're unable to attend to the child's education or medical decision. You could at least elect a third party. Now, on the screen is an example of what the form looks like. It's very easy to fill out, and you would just put your name. You would then put the name of the child and the date of birth. And if you have specific instructions, you could then list it below. And then there's the area for the notary. Now, like I said before, it's really difficult for folks to get documents notarized right now. So if it isn't notarized, it will last for up to a month. However, if you are able to get it notarized, it could be valid for up to a year. Now, the big question that's looming behind everyone's minds right now is, how do we notarize anything in the time of COVID-19? So there was actually about a month ago, the governor issued an executive order authorizing notary services to be able to notarize via audiovisual technology. I've listed on the screen in front of you the step-by-step way of how a notary can actually notarize documents for you virtually. Now, even though this is possible, this is actually really difficult for most families because you have to have, one, an internet connection, two, live video conferencing capabilities. So kudos to everyone who's on this webinar right now. You've already accomplished the first two goals. But the next two are a little bit more complicated. You are gonna need access to a printer, right? So if I'm sending you this document, you're gonna have to be able to print it in order to sign it. And then once it's signed in front of a notary using a video conferencing forum, it could be Skype, FaceTime, it could be Zoom. You then have to send that document to the notary. And this can be done either through fax. Many people do not have a fax machine in their homes right now. The other alternative is to scan it and send it via email. Many people have smartphones now. So even though you may not have a scanner at home or your printer does not have scanning capabilities, your phone could actually scan documents. If you have many folks have iPhones, I have an iPhone, there's actually a scanning capability in the notes function of iPhone. And the reason why I bring that up is because it's going to be a much better quality as opposed to just taking a physical picture with the camera of your phone. And for those who don't have iPhones, there's a free app. It's called Dropbox. And that also gives you the ability to scan documents. And by using these forums, you're able to get a much more legible copy sent to these parties. So in the time of COVID-19, the way that this would work out is, say I want to get a document notarized. I would then schedule a video conference with the notary. I would then, in front of them, show them my valid New York State ID. I would say during the video conferencing that I am present in New York, and I would state what county I live in. And then I would sign the documents in front of them while on the video conferencing. Once that's done, I would scan it with my cell phone and email it to the notary. The notary would then print it. So not only do you have technological challenges, but the notary also must have access to a printer and the ability to scan or fax the document back to you. This is incredibly difficult, but this is the way that it can be done during this current health crisis. So the notary would then print it out, notarize the document, and then scan it, email it to you, or fax it to you. This is incredibly difficult, but it is possible. And I will throw out there that the attorneys that work at MFJ, many of them are notaries. So apart from parental designations, another form of future planning is standby guardianship. Standby guardianship is a way for caregivers or parents to plan for the child's future security. And even before this crisis began, I always urged every caregiver that came to MFJ to really start thinking about, once they've gotten that final order of custody or guardianship, you never know what can happen tomorrow. So it's great to start planning for that child's long-term stability in the event that you're unable to care for that child. Things happen, medical emergencies arise. So who would you want to care for that child when you're no longer able to? This form is a way for you as the caregiver and legal guardian to elect who you would want to care for that child in the event you're unable to do so. And in the form, you can actually say what triggering events you want to apply to the scenario. So it can be, in the event that I die, I want my sister to care for my daughter. In the event that I'm physically or mentally incapacitated, I would want my sister to care for my daughter. You could have it as limiting as you want, or you can include all those scenarios. And now there's actually been a recent development with standby guardianship. In 2018, it was expanded to also include parents facing deportation. So this is also a great resource. I know there's a number of caregivers, but there may also be service providers on this webinar. So if there are immigrant families that are concerned because they may be undocumented, what would happen with the child that's in my care in the event that I am deported, they can also use this form to designate who they wish to care for that child in the event that that were to occur. Now, this form is a little bit different than the parental designation form that I discussed earlier. This form, there's two different approaches with standby guardianship. So the first approach, let's say the person has a terminal illness and is dying, or is in active deportation proceedings. In those scenarios, theoretically, if courts were actually hearing all proceedings right now, they could go to family court and fill out a standby guardianship petition. Now, that's a very small percentage of cases. The larger majority of cases that we advise on at MFJ are the late petition approach. So this means that, you know, the caregiver is in good health, there aren't any immediate concerns, but the caregiver wants to be prepared in the event that something were to occur. Particularly now during this current health crisis, I think a lot of people are, you know, legitimately concerned. What happens if I get sick and I have to be in a hospital, and if something happens to me, who's going to care for my children? So in those scenarios where there really isn't any affirmative diagnosis, but, you know, families want to have that peace of mind and preparedness, what they can do is they can fill out a standby guardianship form in front of two witnesses and keep that in a very safe place. The person that you elect should know where it is. And in the event worst case scenario happens and the person passes away, what would happen is that person who was designated as the standby guardian, so the backup who would take care of the child, could then take that document and file for guardianship in family court. Now, it isn't an automatic guarantee that that person would be granted guardianship, but the prior caregivers, stated preference would be one of the many considerations that the judge would take into account when determining whether or not this person should have guardianship. So it isn't an automatic guarantee, but it does at least have a way for one, the caregiver who's no longer either alive or physically or mentally capacitated, it allows that person to have a say in what's going on with the child's care, which without this form, you otherwise wouldn't have that opportunity. And two, I think it really goes a long way for family to plan what would happen if this person is no longer alive. In our experience, you know, if families don't really talk about what could happen if, let's say, you know, I'm no longer caring for my child because I passed away, but I have a cousin and two sisters, you want to avoid any conflict within the family as to determining who's going to step in to care for this child. So although this is a very difficult subject for many people to talk about and think about, no one really wants to think about their own mortality, but I think it could prevent a lot of issues down the road by starting to have that conversation, you know, with your family members so that everyone's really clear as to, if something were to happen to me, I want this person to step up and care for my children. And I have the form up for you all now. The one good thing about this form is, especially now, given this current health crisis, a lot of people are getting sick. With this form, you could designate the first person that you would want as a standby guardian, and then you could designate a backup. And given the current health crisis, I would honestly recommend, if possible, to make sure that your alternate isn't within your household right now, just because of, there's been situations where entire families are getting sick. So you don't want there to be a scenario where everyone that you have designated as backups unfortunately fall ill. So because of this current health crisis, I would suggest that the alternate person as your standby guardian should be someone who is outside of your immediate household if there are multiple family members in your home. So, because this document requires witnesses, I know the big question that everyone's going to have is, if there's no one in my house right now, who's going to witness me signing this document, especially in a time of social distancing? So there has been an additional executive order that was signed by our governor. This happened earlier this month, that stated the requirements for audio-visual technology witnessing. So it is possible. Similar to notarizing electronically, it is just as difficult because the witness also needs to have, both witnesses need to have access to the internet. They need to have the ability to do live video conferencing. So if they have Zoom or FaceTime or Microsoft Teams or any other video conferencing forum, they also need to have access to a printer or be able to scan or fax documents back. So these are all, incredibly difficult for folks. If you do have multi-family members in your home, maybe you could have one of them be the first witness. So that way there's only one additional person who has to be a witness for the standby guardianship form. It is difficult, but it's possible. So if you are really concerned about this, you can always contact one of our attorneys at Mobilization for Justice, and we can talk through how to, execute this process. So I have the list of instructions below. Like I said, it's incredibly difficult for many people. I think this is important, especially for service providers who may be on the webinar today, if they want to help assist kinship caregivers with witnessing the signing of certain documents. This is the procedure that would have to be followed. Like I said before, the signer, if the witnesses don't know this person personally, they would have to show their valid ID during the video conference. Then they would have to physically sign the document while on the video call. Then on that same day, they have to send a copy of that document to the witnesses. The witnesses would then print it out, sign it, and then they could email it, mail it, fax it to the caregiver. So it is possible, it just is a little bit difficult, but it can be done. So the third item that I wanted to discuss are living wills. And so this really pertains to the question that was at the very beginning of this webinar. So a living will is a written declaration of your healthcare wishes. It's a way, if you're 18 years or older, for you to express what your wishes are in terms of, life-sustaining medical treatment. You can leave very specific instructions on this document on what medical treatments you may or may not want. There could be many reasons why you would want to limit certain medical treatments. It could be pertaining to, religious beliefs or any other ideology that you have. This is a way for you to express that in a written document. You can describe the specific medical situations in which you would accept or refuse medical treatment. You can specify the kinds of medical treatment that you may or may not want. For example, would you wish to be on a feeding tube or not? If there's no brain activity, would you still want life-sustaining medical treatment to be executed on yourself? The way that this form could be executed is also by signing it in front of 2 witnesses, and making sure that the person who's signing the living will is doing so willingly and is not pressured in any way. That's extremely important, and you have to make sure that the living will says that on the document. If you can notarize it, great, but as long as there's 2 witnesses, then that should be sufficient. There are certain minimum requirements, so there doesn't have to be a specific form that you fill out, but as long as the form has your name, has the date that you're executing this will, says exactly what your personal healthcare wishes are, and you sign it, and then there are 2 witnesses who sign and date it, saying that you signed this document willingly, then that's enough. Those are the bare requirements. Right now, there's actually, I'm going to be completely honest, there's a little bit of hesitancy with filling out this form given the current COVID-19 crisis. There have been concerns that if you have a living will executed, that doctors may not perform certain life-sustaining medical treatment on you during this time if your living will stated such. Because of that, I would say if you're going to execute a living will, you should also execute a healthcare proxy, which I'm going to talk about next. So this is one example of what a living will looks like. There's no uniform form to fill out. This one I recommend because it's from the New York Senate's office, and I'm going to provide links to all the forms that I have referenced during this presentation. I just saw the question, very good question, Lisette. The question for those who aren't reading the chat is, does it matter who the witnesses are? And can the witness for living wills and healthcare proxies be signed by a close family member? Yes, it can be signed by a close family member. I would say, obviously, the person that you're designating as the healthcare proxy shouldn't be the witness to this person signing the healthcare proxy, but it can absolutely be a family member as long as that person is 18 years of age or older. So, many of us live in multi-generational households, so it is possible that you might have relatives within your home right now, even though during this time of social distancing, you might have family members in your home who could serve as witnesses. If that's possible, I say go for it, because it's much more easier than having to find someone outside. If you do have a family member who could sign it, then that would make it a lot easier. So then you're only trying to find 1 witness as opposed to 2 who could do this process electronically. So that might be a bit easier for you. Variations of these forms are also often a part of the hospital check-in process. So let's say someone falls ill and is hospitalized right now. These are going to be forms that may be a part of the hospital intake process. If you are unfortunately hospitalized and you're filling out forms and you see that there is a form called a living will, I would ask for a copy of that document. It's not a part of standard hospital discharge procedures, unfortunately, but if it is executed through a hospital and you are discharged at some later point because you've recovered and all is well, then I would definitely ask that the hospital provide you with a copy of any living wills or healthcare proxies that you've signed during your hospital stay. Okay, so healthcare proxies. So living wills are a way for you to designate what medical treatments you would want in the event that you're unable to express what your desires are. healthcare proxy is, who do you want to designate as the person who can make those decisions for you in the event that you're unable to make those decisions yourself? There's a couple of different terms that people use to refer to healthcare proxies. They can be referred to as a durable medical power of attorney, a healthcare surrogate. If you hear these terms, they're all referring to the same thing. It allows you to appoint a person, someone you trust, to make healthcare decisions on your behalf in the event that you lose the ability to make those decisions yourself. Why appoint a healthcare agent in the first place? Number one, it's a way to make sure that healthcare providers, nurses, and doctors follow your explicit wishes. So, in the event that you're unable to express what your desires and wishes are, it's great to have an advocate in your corner who can really push for what you want in the event that you're unable to state that yourself. So the next question that was asked is, if multiple healthcare proxies were signed, which one is most valid? One, it has to be the one that was validly executed. So remember when I talked about living wills, there were a number of bare bone requirements. So let's say there were 2 different living wills. They all satisfied the 5 requirements that I listed above, but one was executed 5 years ago and one was executed last month. The one that was executed last month would take precedence over the one that was 5 years ago. And the reason why this happens is because, familial relationships change, people move, people pass away. So the person that you might have elected 5, 10 years ago may have moved to the other side of the country. They may have passed away. Your relationship with them might have changed. So there could be a variety of reasons for why you choose to elect a new healthcare proxy. If that were to happen, the most recent validly executed healthcare proxy would be the one that would be the most valid. Now, because of this, I always say that when you are executing healthcare proxies, be sure to give a copy of this document once it's executed to the person that you designate. If you're unable to do this, make sure that that person knows where to find these documents. And just, a general tip when it comes to important documents overall, you should make sure that someone knows where to find these things, especially now during this health crisis where we can't really anticipate what's going to happen. People's medical conditions can really decline unexpectedly. It's really important for someone else to know, especially since you are a kinship caregiver, where can they find the child's birth certificate, the standby guardianship form you filled out? Where can they find the child's medical documents, your medical documents, in the event that you have to be hospitalized and they need this form, where your healthcare proxy and your living will is? All of this should be kept in a safe place, and you should let someone that you know and trust be aware of how they can find these documents in the event. And best practice would be to actually give them a copy if you're able to. I know things are difficult right now, so at the very least, let them know where they can find it, but best practice would be to give them a copy. Okay, so with healthcare proxies, you can give this person as little or as much authority as you wish. You are able to really designate how much power you want this person to have. You can actually, also say your wishes with regard to organ or tissue donation on this document as well. Now, this is really important just in terms of designating who your healthcare proxy should be. A couple of things to just warn you about when you're picking someone as your healthcare proxy. There's a preference for at least the proxy to have to not have any religious views that prevent this person from executing or carrying out what your wishes are. So I would just forewarn yourself with that. But other than that, it should be someone that you trust. Right now, I have a copy of the form on the screen. This form is also offered from the New York State Senate's office. I'm gonna be providing everyone with links to all of these forms, like I said before, at the end of this webinar. It's really simple. This form, I like it because it's very clearly, it's well written, and I think it's easy for folks to fill out. You can easily, the proxy would put the proxy's name. Optional instructions would go in number 2. Then what your wishes are in terms of organ and tissue donation. Now, an alternate proxy designation. This is really important, like I said, because of this current health crisis. In the event that that person is unavailable, who do you want as a plan B to be able to make these medical decisions on your behalf? You would put their information there. Then you would, if there are certain conditions that you want to add, you could include so. You sign it, and then it has to be signed like the living will before 2 witnesses, and their signatures would be on the bottom of this form. So what happens when remote document signing isn't possible? I know there's going to be, a number of folks that are on this webinar, or for the service providers, there will be kinship caregivers who won't have access to a scanner or a printer, or may not have internet access or the ability to do live video conferencing. That's completely understandable. What we can do is prepare. So even if there are clients or caregivers who don't have access to this technology, they can consult with attorneys at MFJ, and we can give them information. We could help them draft documents so that when it is safe to execute documents like this in person, everything would be ready to go. So even if you don't have access to this technology or the ability to print or scan or fax, don't be discouraged. I think it's important to, at the very least, start having these conversations, start thinking about it, and having these conversations with their family to make sure that there is a plan in place for the children that are in your care. And if you feel comfortable, you can also talk to one of our attorneys at MFJ, and we can talk through all the pros and cons with the decisions, so that way when it is safe to execute these documents, you're prepared and ready to go. So I just wanted to recap on the 4 different topics of today's webinar. Parental designation is what we went through first. And parental designation is a way for you to appoint a person who can make limited medical and educational decisions on behalf of the child. This is a great form for temporary decision-making abilities. It can be used even if it's not notarized for up to a month. And it is a tool that every caregiver, every parent should at least have in their toolbox, because you never know what can happen down the road. You might go on a nice long vacation one day, right? When it's safe to travel. Who are you leaving that child with? Do they have some limited decision-making power over your grandchild while you're on vacation? This form can help with that. Standby guardianship is a way to plan for the child's future, security in the event that you're unable to care for them. So what if something happens to me? Who do I want to care for? My son or daughter, my grandson, my niece, nephew? It's a way for you to elect the person, and even a secondary individual if that first person isn't available. And I think it's a way for folks to have a great amount of security and peace, knowing that there at least is a plan in place if something were to happen. Third, healthcare proxy. It's the person that you appoint to make healthcare decisions on your behalf in the event that you're unable to express those wishes yourself. And finally, living wills. It's a written declaration of what your healthcare wishes are in the event that you are no longer able to decide for yourself. Now, I am including some future planning resources for folks. These are links for all of the forms that I've referenced throughout this presentation. We're going to be emailing this to each of you, so don't feel the need to write this down right now. There are also some resources that I want to share with everyone that are specific to COVID-19. MFJ, all of our staff, even though our physical offices are closed, we do continue to service clients remotely. And so because of that, we've expanded our intake hotline hours. We do have the ability to do virtual conferencing with clients if that's something they wish to do. So I'm going to also include links to our expanded intake hours, many fact sheets that are really relevant now during the current COVID-19 crisis. So these are fact sheets regarding public benefits, housing, economic impact state payments, and other related issues that folks are encountering now. And finally, there is a list of resources that are available throughout the city. It could be food pantries or other resources that you can find on the third link. And Generation United actually issued another fact sheet specifically for grand families and multi-generational families that I wanted to include as well. So all of this, it's a lot of information, but it will be sent to you electronically. Now, last but not least, I did want to include the Kinship Caregiver Project Hotline. So our hotline is open on Monday, Wednesdays, and Fridays from 10 to 5. During that time, you can speak to an attorney. We can provide advice on many of the future planning matters that we discussed in this webinar, but also if you just have questions about custody or guardianship, or if there's a child that's in foster care and you have questions about either visitation or how to advocate for that child, call us and we can advise you on that. So that's pretty much it. I believe I've answered everyone's questions, but if there are any other remaining questions, I do believe we have some extra time.
All right. Thank you so much, Jackie. I appreciate your time.
I'll know you're done when you type in your answer for Monarch.
And I will be sending out the email shortly for everybody's online resources. And
this is where your accuracy things. Accuracy.
I do see that. Okay, so there was a question about going over witnessing and power of attorney. So I want to be clear, for power of attorney, the healthcare proxy form, there's a form that will be a link that is sent out to everyone. The process for executing that, the kinship caregiver should be on let's say a Zoom call, for example, with the two witnesses that they wish to be witnessing the execution of the document, right? So in this call, what they would do is they would take out the document. Once they have it filled out, they would sign the document during the video conferencing call. Once that call is completed, they would then scan it, email it to the witnesses, who would then print it, sign it, and send it back to the client. That's how, in the time of COVID, these documents could be electronically witnessed. If it would be helpful, I could pull it up again and we can talk through the actual questions on the form if that's what's confusing folks a bit.
Hey everyone, I'm Jamari. I'm actually the Youth Services Coordinator for PSS. I just wanted to introduce myself as part of the team. I want to thank everyone for attending. I want to thank Jackie for leading this. Once again, look out in your email for the resources that you will be sent. And also as a little plug, just remember to do the census. That's very important during this time. So thank you for everyone. We'll be in here for a little bit longer if you have any more questions. But yeah, thank you.
Hi, I got some questions about contacting me directly. If you are a kinship caregiver and have a question regarding any of these matters, you can contact our hotline. We're going to send also my contact information and the hotline's contact information below. If you are a service provider and you have questions about, clients' eligibility, if you have a forum where you would like a similar webinar for clients that you are servicing, I'm more than happy to do that. I could also do a webinar on custody, guardianship, adoption, other areas that might be of interest to kinship caregivers right now. Those would be the reasons for why you would want to contact me directly. But if you are a kinship caregiver and you just have questions about future planning in general, any of our staff are more than adequate to provide you advice with any of this. And the way that you could do that is by contacting our hotline, and our hotline is toll-free. And we do have Spanish-speaking attorneys on staff as well. So if there are non-English speaking caregivers who have questions about this, they shouldn't be deterred from calling our hotline. Okay, it looks like we have a couple of more minutes, and I know there were some questions about the healthcare proxy. So if everyone's okay with me just going over those slides really quickly one last time, I'm gonna do so. In the meantime, if you're still listening, I think there were some questions about whether or not this webinar is recorded for folks to access for future use.
Yes, it is recorded, and I can send out that link as well. Thanks, y'all, for being patient.
All right, so I'm gonna just jump back to the healthcare proxy section, which I think was a little bit confusing for folks. So like I said, this form is a way for you to designate a third party, a family member to make medical decisions on your behalf. Here's one example of what the form looks like. You can find different forms online. I like this form. It's from a reputable source. I'm going to send a link for everyone to access this form online. And this is also included with the living will. So it's a quick 2-page document that clients can easily execute. Now, on this form, for section 1 would be who is the healthcare proxy, right? So I, caregiver, appoint proxy number 1, their address, their city, their state, their contact information, right? So then in section 2, this is optional. If you have specific instructions for this person, you can include that here. Then in part 3, you can state what your wishes are for organ or tissue donation. It's completely optional. You can elect to do so or not. Then 4 is, if this first person that I designate as a healthcare proxy is unavailable, who do I want as an alternative? You can put that person's contact information in section number 4. 5, unless I revoke this healthcare proxy, shall remain in effect indefinitely or until the date or condition stated below. Some people feel a little uncomfortable by having a person designated as their healthcare proxy indefinitely. So if you wish, you can state certain conditions. It can be, I only want this healthcare proxy designated for the next month or so, or for as long as I'm hospitalized at this specific facility. Whatever conditions you're comfortable with, you can elect so there. And I think it's actually a great idea to put a time frame, just so you're continuously thinking about this and making sure that you're putting someone who makes the most sense. So like I said before, family relationships might change, people might move. So who you designate today might not be the same person that you would elect 5 years from now. And then finally, signature. So caregiver, you would sign this document in the video conferencing app. Your witnesses would be watching you sign this. Then you would scan it, either, if your printer allows you to scan it. If not, you would use your smartphone to scan it, and you would email it to the witnesses. The witnesses can then sign it and then email it back to you, or mail it back to you if you want the original. Those are the options on how to execute it. All right, there's one more question about the healthcare proxy form, which is, can the designee be contingent, or are you limited to one? And if one can't, can the other do it alone? In terms of the healthcare proxy, you don't have to have an alternative. You can only do one if you're only comfortable with one person. But the alternate here, the way that this form is drafted, is only eligible to be a healthcare proxy if the first choice is unable, unwilling, or unavailable. So like I said before, what if the first person you designate as proxy moves to Connecticut and you're hospitalized in Brooklyn, and the only person who can physically get to Brooklyn right now is your backup? Then your backup would have the ability to make those decisions on your behalf. I hope that clears it up a bit. So in the question is, if you have 2 children over 18 that you want to designate as your healthcare proxies, it might feel a little weird, like you're designating a first and second pick, but like the question was posed on the chat, if one child is unavailable and the other is, then that child can make the decisions if they are elected as one of your healthcare proxies, whether it was the first one on this list or the alternate. Either way, they can make decisions if the other person is not available. So I think that pretty much answered the question. If there are any other questions regarding healthcare proxies or living wills or any of the other material we discussed today, feel free to put so in the chat. And it's nice to meet you, Miss Woods. Seems like you've been a caregiver for quite some time. So if you have a question, Ms. Woods, I definitely urge you to contact our hotline, and you can speak with any of our attorneys on staff. We're more than happy to help you with any legal questions you might have.
And if wait, is there another question? Hold on.
It says here, can 2 persons be listed as primary? So like I said before, you shouldn't really think of it as first choice and second choice, if you're using the form that I'm sending you from the Senate's office, because if one is unavailable, the other one could do it. It doesn't make, it doesn't mean that they have to search for the first person and exhaust all opportunities before listening to who the second person who's listed. You shouldn't think of one as primary as opposed to the other, but I would say that you should start thinking about, are these 2 siblings going to get along? And you don't want to have a situation where folks are fighting about what decisions are going to be made on your behalf. So that is something to think about. Because a worst case scenario would be, what if both people show up to the hospital and they disagree about your treatment? That could be a bit complicated.
Okay, so unfortunately, we do have to cut it off right now. Thank you, everyone, for coming up. Thank you for all your questions. We really
Thank you guys so much
appreciate
for coming, and thank you so much again, Jackie.
Thank you. Be well, everyone.